Good afternoon, everyone. So, today we shall be discussing about the construction of Indian Collegium system. So, the construction of Indian Collegium system, like we have already read much about the appointments of the judges of the higher judiciary. We have under Article 124 of the Constitution of India the whole process regarding the appointments and transfers of the judges of the higher judiciary. Okay, so this appointments and process thing is very contentious in the contemporary legal discourse, because the appointment is not as straight and simple as it should have been. Or, good afternoon, everyone. Or we can say that right now, the process of the appointments of the judges of the higher judiciary is under attack because of some political forces or political reasons. Judiciary as an independent institution is the guardian of our rights. Okay. And it often happens that judiciary as an independent institution and as a guardian of the rights of its citizens comes in direct conflict with the state's policies and state's actions. Because some of these state's actions and policies are often deemed at or intended at attacking the rights or violating the fundamental rights of its citizens. Every person who comes to power, whether in a democracy or in any form of government, any other form of government, they have a tendency towards dictatorship and towards usurping more and more power. And this is possible only when the fundamental rights of the citizens are diluted or violated. Whenever the executive has tried to encroach upon the rights of its citizens, judiciary has come all the way in between to protect the rights of its citizens. This has happened time and again. And this is what actually has brought judiciary and executive in direct conflict with each other. So the executive has also tried its best to take the appointments and transfers of the judges of the higher judiciary into its own hands, so that it may get an instrument or it may hold back the yoke. You know what is a yoke? It may hold the yoke in its hand to regulate and to drive the judiciary in its own way, so that the judiciary and as an institution should work for the benefit of the executive rather than protecting the fundamental rights of its citizens. So the process and the issue of the appointments and transfers of the judges of the higher judiciary has become very contentious in the contemporary legal discourse. Okay, Article 124 of the Constitution of India, it talks about the judges of the appointments of the judges of the Supreme Court, while we have a corresponding provision in the Constitution, which is Article 217 regarding the appointments of the judges of the high courts. Okay, the process is all the more same. If we are reading Article 124, you would automatically understand Article 227 or any other provision concerning the appointments of the judges of the high courts. So let us first understand what is there under Article 124 of the Constitution of India. But before that, you should also understand and you should also make this clear that this is not concerned with the appointments of the judges of the district court, of the subordinate courts, because that happens through a competition, through an entrance examination. Whoever qualifies it, goes through it. Okay. While the appointments made at the higher level are, they are not subject to any sort of examination. They are selected on the basis of the basis of the record of the practice of an advocate. Whosoever is doing his best should be taken up and should be asked to sit as a judge and dispense justice. So this is what has been happening. So Article 124 of the Constitution, if you have the bare text of the Constitution, you should go through this. There shall be a Supreme Court of India consisting of a Chief Justice of India, and until Parliament by law prescribes a large number of not more than 7 other judges. Every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal after consultation with such of the judges of the Supreme Court and of the High Courts and states as the President may deem necessary for the purpose, and shall hold office until he attains the age of 65 years. Okay, so who is going to appoint the judges of the Supreme Court? He's the President. The same is the case with, the High Courts. The President appoints the judges of the higher judiciary. Who appoints them? The President appoints them. Okay. But that's a common fact, and everybody knows it, that the President in India is just a mere rubber stamp. He cannot do anything without the orders of the executive, because whatever the President does, he does it on the aid and advice of the Council of Ministers headed by the Prime Minister. So President's actions are not on his own. Okay, President's actions are not his own actions. His actions are actually the actions of the executive. So if the President of India is appointing the judges of the higher judiciary, then that means that the appointments process is indirectly falling into the hands of the executive, which creates a very big question mark, which puts a very big question mark on the independence of the judiciary. That if the appointments and process of appointment of the judges of the higher judiciary is indirectly in the hands of the political actors, then how then we can say that judiciary is an independent institution and it works free from any sort of political influence? We cannot say that, because judges at the end of the day, it does not matter. Actually, at the end of the day, we have to understand the judges are also the human beings. Howsoever howsoever honest they may be, at the end of the day, you can influence or manipulate a human being if his appointment and his salaries and his benefits are in your hands. Okay. Howsoever I or you may be, if the appointment process is in the hands of the government, then definitely that judge will think 100 times before he writes anything against the government. So this is how it creates a blot on the independence of the judiciary. Okay, so it simply says that every judge of the Supreme Court shall be appointed by the President of India by a warrant under his hand and seal. By a warrant under his hand and seal after consultation. Now this is important. After consultation with such of the judges of the Supreme Court and of the High Courts in the states, as the President may deem necessary for the purpose, and shall hold office until he attains the age of 65 years. So you have to understand this, that the judges are appointed by the President. Judges are appointed by the President, but only after consultation with the Chief Justice of India and such other judges as he may deem fit and necessary. Okay, as he may deem fit and necessary. Now listen to me very carefully. President is the appointing authority. He is appointing Mr. A, Mr. B, Mr. C on the suggestion and on the orders of the Council of Ministers, who are prompting from his back, okay, to be headed by the Prime Minister. There is a Council of Ministers headed by the Prime Minister. They are prompting some of their favorite names. Like, for example, if there is any advocate who holds the government's view or whose political views are exactly like that of the government, then the government, being the government's favorite person, his name can be suggested by the Council of Ministers to the President. Now the President has to appoint Mr. A, B and C because these names have been suggested by the Council of Ministers headed by the Prime Minister. On the other hand, the process does not stop here. The President has to consult the Chief Justice of India and such other judges as he may deem fit and necessary. Now this consultation with the Chief Justice of India, the question is, the president is being prompted from behind by the Council of Ministers. Then the president has to consult the Chief Justice of India and such other judges. Now, what if the consultation with the Chief Justice of India renders a conflict between the opinions of the Chief Justice of India and other judges and the opinions of the Council of Ministers as suggested by the Prime Minister? What the president will become like in between, his position becomes awkward. The whole chain is like the position of the president has become quite awkward, because on the right of the president is the Council of Ministers, on the left of the president is the Chief Justice of India and other judges of the Supreme Court and of the High Courts. Okay, they are saying appoint Mr. A, B and C, while they are saying appoint Mr. X, Y and Z. Don't appoint Mr. A, B and C. Then how is that going to work? Because what the president is supposed to do in case there is a conflict of opinion between the two, what the president is going to do? So the question arose that if the president has to consult, it's written there in clause 2, if the president has to consult the Chief Justice of India and other judges of the Supreme Court while making this appointment, then, and if there is any conflict of opinions between the opinions of the Chief Justice of India, this Collegium of the judiciary, and the Council of Ministers, then whose opinion shall have the primacy in the appointments process? Whose opinion shall have the primacy in the appointments process? So this is a serious issue which has to be dealt. The document that I have shared, the PDF document that I have shared with you, it contains 20 pages. Like, it's a very long and lengthy document and you have to go through it. Like, I cannot read each line of it. That's not possible today. Okay. But I'm going to discuss it summarily. The appointment of judges is a critical element of judicial independence, which calls for that during administering justice, judges have to be free from all types of direct or indirect impact of political or non-political. The independence for judiciary could be very essential so that the judges may be unbiased and perform their responsibilities successfully and without any form of worry and favor. The liberty of judges has a near dating with judicial appointment, because the appointment of choose via the head of the state is observed in most of the international locations of the arena. Appointment through the top of the state with the sessions of the Lord Chancellor changed into basically the British technique, which changed into adopted within the Indian Charter supplied underneath Article 124 of the Indian Constitution, which states that. Okay. Now this is the text. Okay. I'm reading this. The mechanism for judicial appointment performs an essential function in deciding having the professional capabilities and features which can be required for judges in an unbiased judiciary. This its principal cause is to analyze how the existing mechanisms for judicial appointments are effective in preserving judicial independence and public self-belief in the judiciary. Okay. Now the question is that if somebody, like, you have to Somesh is asking, is president bound by the suggestions? Is president bound by the suggestion? President is not seen. Which suggestion? The suggestion of the Council of Ministers or the suggestion of the Collegium? Which suggestion are you talking about? Which question are you talking about? of Council of Ministers, yes, the President is bound by the advice of the Council of Ministers headed by the Prime Minister. I have already told you, whatever the President does, he does it on the aid and advice of the Council of Ministers headed by the Prime Minister. So the question is simple, that President is in the middle position. On the right is the Council of Ministers headed by the Prime Minister. On his left is the Collegium of Judges headed by the Chief Justice of India. Both of them are making recommendations to the President. There is a difference of opinion between the Council of Ministers and the Collegium headed by the CJI. Whom the President should listen to? That is the question. Are you getting my point? Okay. Whom the President should listen to? So the judicial question arose that whenever there is a doubt or any ambiguity as regards the interpretation of the text of the Constitution or any law, the Supreme Court throws some light and interprets it in a way so that it can be understood even by a common man. So Article 124 of the Constitution was first interpreted by the Supreme Court in Sp Gupta case. That is popularly known as the first judge's case. First judge's case, Sp Gupta versus Union of India. Okay, it declared that the recommendation or the consultation, the word consultation, there is a word consultation, because the President has to appoint them under his warrant and hand and seal after consultation with the Chief Justice of India and such other judges. The question supposed to be mooted upon was whether this word consultation has a binding effect or is it just a formality only to ensure the participation of some of the top judges of the country in the appointments process. Okay, in the appointment process, the question was that the word consultation, does the word consultation has a binding effect or it simply has, or it has been, or is it simply has been kept as a formality just in order to ensure the formality, just in order to ensure the participation of the top judges of the country. The question was this. So the Supreme Court in the first judge's case in Sp Gupta versus Union of India, ठीक है, the ruling gave the executive primacy over the judiciary in judicial appointments for the next 12 years. Okay, for the next 12 years. The ruling said that the consultation is not binding. The consultation of the President the consultation of the President with the Chief Justice of India and other judges is not a binding consultation and it is just a formality. If there is any conflict between the opinions of the executive and the judiciary, then the primacy will be given to the opinion of the executive, and executive shall have the primacy in matters of appointments of the judges of the higher judiciary. You listen to me very carefully. Please listen to me. You can read the document afterwards. You listen to me carefully right now. Okay. Okay. I am simplifying it. This is a very complex issue. I am simply simplifying it so that you can understand it in the simplest manner. Otherwise, there's a lot of debate and lot of things involved in this issue. So the first judge's case was the Sp Gupta versus Union of India, in which the question to be mooted upon was whether the word consultation has a binding effect or it simply has a formal existence or formal presence in the text of the Constitution only to ensure the participation of the judges of the higher judiciary in the appointments process. The question decided by the Supreme Court was that the word consultation is just a formality, and if there is any conflict between the or difference of opinion between the suggestions and recommendations of the Council of Ministers and the judiciary, the primacy shall be given to the opinion of the executive in matters of appointment, and all the suggestions and recommendations of the judiciary shall be kept aside. Okay, this is the first judge's case, Ankita. This is the first judge's case, Sp Gupta versus Union of India. Okay, this is Sp Gupta versus Union of India. Okay, this is the first judge's case. Now, the second judge's case. Okay, now the primacy was given to the executive. Primacy was given to the executive. Consultation with the Chief Justice of India. Now I am reading the Constitution, Article 124. There is a proviso to Clause 2, provided that in the case of appointment of a judge other than the Chief Justice, the Chief Justice of India shall always be consulted. Okay, shall always be consulted. अब इसमें एक सेकेंड प्रोविजो भी है, वो अभी हम नहीं पढ़े क्योंकि वो रिमूवल प्रोसेस से रिलेटेड है. वी आर नॉट रीडिंग दैट, वो रिमूवल प्रोसेस से रिलेटेड है. आई एम रीडिंग दिस. प्रोवाइडेड दैट इन केस ऑफ अपॉइंटमेंट ऑफ अ जज अदर देन द चीफ जस्टिस, the Chief Justice of India shall always be consulted. Shall always be consulted. But the question was that whether the recommendation sought through the consultation, sought from him through the consultation was binding on the president or not. The Supreme Court said no, it was not binding. It is simply a formality. ये सिर्फ एक औपचारिकता है और इसकी पाबंदी करना, इसको मानना अनिवार्य नहीं है राष्ट्रपति के ऊपर. It is not mandatory for the president to follow the recommendations of the CJI and other judges. This is Sp Gupta versus Union of India. Okay, simple. Are you getting my point? Now the question arose because already some cases had happened that during the prime ministership of Mrs. Indira Gandhi, Justice A.N. Ray was, superseded 3 senior most judges of the Supreme Court and was overnight elevated to the post of Chief Justice of India. However, this is not a constitutional rule. This was not a rule that a senior most judge would always become the CJI. This is not the rule, but this had become a custom in India because since the enforcement of the constitution, since day one, this was being practiced. बात जज्बात और तुम्हें saying, but it has been omitted by 99th amendment. अभी हम 99th amendment पर कहां पहुंचे हैं? अभी तो हम हिस्ट्री पढ़ रहे हैं. अभी तो हम एसपी गुप्ता वर्सेस यूनियन ऑफ इंडिया में 1980s में, अभी हमें 1993 का जजमेंट पढ़ना है. उसके बाद हमें थर्ड जजेस केस पढ़ना है, फिर हमें फोर्थ जजेस केस पढ़ना है. तो 99th अमेंडमेंट तो फोर्थ जजेस केस में आएगा ना. अभी रहने दीजिए उसको. ठीक. नाउ द प्रेसिडेंट, where was I? I'm sorry. The SP Gupta versus Union of India में ये डिसाइड हुआ था कि the executive shall have the primacy. Yes, I was telling you, during the prime ministership of Mrs. Indira Gandhi, Justice A.N. Ray superseded 3 senior most judges of the Supreme Court because he was on the 4th serial number in the list of seniority, and he superseded 3 of his senior judges and was made to become the CJI overnight. This happened only because Justice A.N. Ray used to write some favorable judgments for the government and for the government, and Mrs. Indira Gandhi gave him the privilege of becoming the Chief Justice of India. This was actually a custom that the senior most judge would become the CJI. That is not the legal rule. That is not the constitutional law. That is not the law. That is a custom. But every such custom has to be respected. So all the three senior judges, they resigned immediately because they were paying for not writing judgments in favor of the government, Indira Gandhi government. So this is what actually happens when the appointment processes of the judiciary, they fall completely into the hands of the executive. Executive would always make political appointments. And when political appointments are made to an institution like judiciary, what do you expect of an institution where every judge's appointments are made with some political benefits or political motives? Okay. The seat of the judges is not a politically motivated seat. It's a seat to dispense justice. So a person whosoever intends to sit on that chair has to be very honest, and he has to be free from any sort of political influence. This question arose again. This question arose again in 1993 in Supreme Court Advocates on Record Association versus Union of India. And this became the second judge's case. Okay. Supreme Court Advocates on Record Association versus Union of India. You listen to me very carefully. I'm making a very important point. The Supreme Court Advocates on Record Association versus Union of India में जो भी सुप्रीम कोर्ट ने कहा था एसपी गुप्ता वर्सेस यूनियन ऑफ इंडिया में, whatever the Supreme Court had opined in first judge's case of SP Gupta versus Union of India was completely reversed in the findings of the second judge's case. The Supreme Court opined in the second judge's case in Supreme Court Advocates on Record Association versus Union of India that the word consultation has a binding effect, and in case of a dispute between the opinions of the Council of Ministers and that of the CJI or the Collegium, Judicial Collegium shall have the primacy in the appointments process. Shall have the primacy in the appointments process. And I'm reading the finding of the Supreme Court. Initiation of the proposal for appointment in the case of the Supreme Court must be by the Chief Justice of India. Who is going to initiate the appointment process? The Chief Justice of India. Who is going to say that there are vacancies lying in the Supreme Court and we have to make some appointments? It's not the government who has to initiate this process. It is the CJI who has to initiate this process. This is what the Supreme Court said in 1993 in the second judge's case, that the CJI has to initiate the appointment process in case of vacancies in the Supreme Court, and in the case of a High Court by the Chief Justice of that High Court. And if there is any vacancy in the High Court, then the Chief Justice of that High Court will make this initiation, will initiate the appointment process that there are vacancies lying in his High Court and they are supposed to be filled. Okay. And in the case of a High Court by the CJ of that High Court, in the event of conflicting opinions by the constitutional functionaries, the opinion of the CJI has primacy. The opinion of the CJI has primacy, meaning thereby the opinion formed collectively. It's not, CJI is not all alone. He has other judges along with himself. Okay. He has judges all along with himself, because if you read the text of the Constitution under clause 2 of Article 124, it's written, and after consultation with such of the judges of the Supreme Court and the High Courts, as he may deem fit and necessary, like such of the judges. It's not as one judge. There are so many judges involved in the consultation process. So CJI is not all alone. There is an opinion which has been formed collectively. CJI is sitting with other judges also. Okay. The opinion of the CJI has primacy, meaning thereby the opinion formed collectively. No appointment of any judge to the Supreme Court or any High Court can be made unless it is conformity with the opinion of the CJI. unless it is in conformity with the opinion of the CJI. Okay. The Supreme Court found that the majority view in Sp Gupta versus Union of India, giving primacy to the central government in the matter of appointment of judges to the superior courts, it was held, does not lay down the correct law. It is not correct in the eyes of law. The Supreme Court said no, whatever was said by and found by the and opined by the Supreme Court in Sp Gupta versus Union of India was not correct in the eyes of law. Okay, it was overruled to that extent, and it was overruled to that extent. Okay. The executive means who is the head of the executive? De jure head of the executive. There is one de jure head of the executive and there is one de facto head of the executive. De jure head of the executive is the President of India. That means by law he is on the top. He is at the top. Okay, the president. The president is the de jure. De jure means by virtue of law. He is the de jure head of the executive. And who is the de facto by reason of fact? The Prime Minister is the de facto head of the executive. So the executive contains President and the Council of Ministers. Okay, so the executive, this executive is bound by the recommendations of the CJI in the matters of appointments of judges under Articles 124 Clause 2 and 217 Clause 1. Okay. Consultation with the CJI. The Supreme Court was supposed to decide upon the consultation, the word consultation, okay, whether this consultation is binding or not. The relevance and significance of the word consultation. Okay, the word consultation with the CJI in the context of appointment of judges to the Supreme Court and high courts must be seen in the background of the constitutional scheme. Okay. The derivative meaning of the word consultation would depend not merely on its ordinary lexical definition, but greatly upon its contents according to the circumstances and the time in which the word or expression is used. Article 124 Clause 2 envisages two kinds of consultation, one being discretionary on the part of the President and the other being mandatory under the proviso. There are two kinds of consultation. One is the discretionary. If you read the proviso, you will find a compulsory consultation, mandatory consultation. Okay, provided that in case of appointment of judge of a judge other than the Chief Justice of India shall always be consulted. Okay, so basically, you know, the gist of the discussion of the second judge's case is that the primacy was given to the Chief Justice of India and other judges to the opinion of the Chief Justice of India and other judges, thereby an opinion formed collectively. So this collective opinion of the judiciary was given primacy over the opinions of the executive, and executive was held to be bound by the opinion of the Chief Justice of India and other judges. Okay, are you getting my point? Are you getting my point? So the question is now, okay, if you have any doubt up till here, you can ask. Questions are welcome. Okay. Okay, so Ankita is asking about the collegium system. That's what we are going to discuss now. The third judge's case. The third judge's case was a presidential reference case. Do you know, you must have read and learnt about various jurisdictions of the Supreme Court. There is one original jurisdiction, there is one appellate jurisdiction, and there is one advisory jurisdiction of the Supreme Court. Original jurisdiction is simply is possessed in the matters where the matters can reach to the Supreme Court directly. Appellate jurisdiction is simply the power to entertain appeals from the lower courts. While advisory jurisdiction is that whenever the executive confronts any ambiguity or doubt while interpreting any law, then the question is referred to the president, and via the president, the question is referred to the Supreme Court for throwing some light by its interpretation of that particular law or the impugned provision of that law. So this is an advisory jurisdiction of the Supreme Court, where the president on behalf of the executive seeks an opinion of the Supreme Court on a point of law. This is known as advisory jurisdiction of the Supreme Court. So it's not that the president would simply call the Chief Justice of India and would say that how do you interpret this provision, and he would tell him on a call that this is the meaning of this provision. No, if some opinion is sought from the president by the president from the Supreme Court writes the judgment in the same way like it does in an original jurisdiction, or while dispensing in SLP, or while dispensing a writ, or while dispensing any appeal. It's a full-fledged judgment. Yes, it's Article 143 of the Constitution, advisory jurisdiction. The Supreme Court has to write a full-fledged judgment. While explaining that point of law, the Supreme Court can go up to writing hundreds and hundreds of pages. So it is like a judgment. So any case which is referred to the Supreme Court by the president is known as presidential reference case. And the third judge's case of 1998 was the presidential reference case of 1998, where the president sought a reference from the Supreme Court of India to throw some light and clear the ambiguity, remove the ambiguity on the collegium system. What is the collegium system? Like, the text of the Constitution simply says such of the judges of the Supreme Court and of the high courts in the state as the president may deem fit and necessary for the purpose. Such of the judges. Now this word such of the judges, like कुछ जजेस से कंसल्ट, अगर हम आपसे कहें इसको हिंदी में इसको ट्रांसलेट करें तो आई वुड से कुछ जजेस से, कुछ न्यायाधीश से कंसल्ट कर लिया जाए, like such other judges. What do you mean by such other judges? The phrase such other judges does not contain an exact number of judges. How many judges will be there? Like there will be 2 judges or 3 judges or 4 judges. This is an ambiguity. Like, while on a bare perusal of the text of the Constitution, of the text of the Article 124, one would simply get confused. What do you mean by such other judges? There should be exact number, either 4 judges or 5 judges. Okay, so the president sought this reference from the Supreme Court on this point of law, that the Supreme Court should make this clear and remove this ambiguity while telling the exact number of judges in the collegium system, because there is an opinion which is formed collectively. There is Chief Justice of India sitting along with some other judges. What is the number of total judges sitting together and forming an opinion collectively, which is binding the president to follow? Okay, which is binding the president of India. So this was sought. In third judge's case, the 9 judges bench opined the subsequent factors almost about the appointment of judge. The opinion of the CJI having primacy within the consultative technique and reflecting the opinion of the judiciary must be shaped on the premise of consultation with the collegium comprising the CJI and the 4 senior most judges of the Supreme Court docket. They decide who is to succeed the CJI or to additionally be protected if he is not one of the 4 senior most judges. Their perspective must be received in writing. Okay. Now I will tell you that the collegium, if one of you was asking, Ankita was asking collegium, what is the total number of judges sitting there in the collegium? There is Chief Justice of India and 4 senior most judges of the Supreme Court and 4 senior most judges of the Supreme Court. Like together they are going to be 5 judges. Together they are going to be 5 judges who are going to form this collective opinion and make recommendations to the president, will provide consultation to the president of India, which will then bind him to follow the opinion. ठीक है? यहां तक कोई प्रॉब्लम है? Yes, 5 judges. Okay. Any question up till here? Any question? Now, if you do not have any question, then let me go ahead now. The government then framed the National Judicial Appointments Commission. National Judicial Appointments Commission. See, the government thought कि पूरा appointment process, the full appointment process, the whole appointment process of the judges of the higher judiciary has been taken over completely by the judiciary. And this is an alarming situation for the government, because the government, whenever the government would try to encroach or do anything, the Supreme Court won't let it do, because judiciary has become very strong as an independent institution. Because the appointments have fallen completely into the hands of the judiciary itself after the second judge's case and after the third judge's case. Okay, so the government planned something. The government thought that we are going to do something to have and make mark our participation in the appointment process. Like, we have to participate in the appointment process. We can't keep ourselves at bay. Okay, so we have to make this very clear. So you listen to me very carefully. The government brought Constitution 99th Amendment Act. Constitution 99th Amendment Act. Okay. The Constitution 99th Amendment Act was brought in 2013 along with National Judicial Appointments Commission Act. This amended Article 124 of the Constitution of India and also incorporated a new article called Article 124 capital A. 124 capital A. Article 124 was first amended by the Constitution 99th Amendment Act. It said that the word president was replaced by NJAC, National Judicial Appointments Commission, and it was mentioned therein that the appointment shall be made in place of the president. That was written NJAC, that the appointment shall be made by the NJAC, National Judicial Appointments Commission. Appointment shall be made by the NJAC, National Judicial Appointments Commission. And Article 124A, the new article which was incorporated in the after Article 124, contained the establishment of the NJAC, National Judicial Appointments Commission, and its composition. So the NJAC was brought. The composition of the NJAC was that See, the 7-member National Judicial Commission was proposed via the committee addresses most of the troubles in an effort to bring duty and transparency within the subjects relating to the appointments and transfers of judges. Okay, now the composition of the NJAC could consist of the Chief Justice of India as the chairperson, 2 other senior most judges of the Supreme Court. Okay, 2 other senior most judges of the Supreme Court. So in total, 3 members from the judiciary. One is Chief Justice of India and 2 other senior most judges of the Supreme Court. Like 3 members ho gaye. Then 4th, the Union Law Minister. Okay, this regulation is a typo here. Union Law Minister. Okay, then 4th, 2 eminent individuals to be nominated through the Prime Minister, CJI and Leader of Opposition of the Lok Sabha. Okay, the Chief Justice of India, 2 other senior most judges of the Supreme Court, the Union Law Minister, okay, 2 eminent individuals to be nominated through the Prime Minister, like 3, 4, 5, 6. It's the composition of the NJAC would consist of 6 members. Like 3 members from the judiciary and 3 members from the executive. Okay, 3 out of those 3, there's one Union Law Minister. And there's going to be 2 eminent people. Now these 2 eminent people can be anyone. Okay. And they will be nominated by a 3-member committee. Prime Minister, the CJI and the Leader of the Opposition of the Lok Sabha. Prime Minister, the CJI and the Leader of the Opposition of the Lok Sabha. Okay. So the NJAC would consist of, the composition of the NJAC is this. The Chief Justice of India as the chairperson, 2 other senior most judges of the Supreme Court, the Union Law Minister, 2 eminent individuals to be nominated through the Prime Minister, the CJI and the Leader of the Opposition of the Lok Sabha. Okay. Okay. Now this coming of NJAC, this National Judicial Appointments Commission, was an alarming precedent, was a dangerous precedent. The constitutionality of the Constitution 99th Amendment Act was challenged before the Supreme Court, again by the Supreme Court Advocates on Record Association. And again, a case, it culminated into a full-fledged case of Supreme Court Advocates on Record Association versus Union of India, which popularly came to be known as the 4th judge's case, decided in 2015. 2015 mein it was decided. Okay. It was decided in 2015. The Supreme Court annulled the Constitution 99th Amendment Act, and it held it ultra vires the basic features of the Constitution. You would have read much about the doctrine of basic features, doctrine of basic structure. The doctrine of basic structure propounded by the Supreme Court in case of Nanda Bharti versus Union of India contains as many things as the Supreme Court wishes to, the Supreme Court has the power to extend the ambit of the doctrine of basic structure to anything. Like independence of judiciary is one of the basic structure of the Constitution. So primarily this was contended before the Supreme Court that NJAC is a calibrated attack on the independence of the judiciary. There is a composition which has been created deliberately by the government where 3 members from the judiciary have been kept while 3 others are from outside the judiciary. 3 members are from the judiciary and the rest 3 are from outside the judiciary. Just the way they have amended the Constitution and have incorporated Article 124A for the establishment of the NJAC and it's providing its composition also. Tomorrow they can very easily amend Article 124A again and change the composition of the NJAC again while throwing all the members of the from the judiciary outside the NJAC. And this is going to be a dangerous precedent. So this is a long-term planning and it is a calibrated attack on the independence of the judiciary. So this was vigorously contended before the Supreme Court that this composition and the establishment of the National Judicial Appointments Commission is a dangerous precedent and it is a calibrated attack on the independence of the judiciary, and therefore it should go away because it is ultra vires the constitution, because it is attacking the independence of the judiciary, which is the basic structure. Okay, are you getting my point? So these are the important features. National Judicial Appointments Commission was held to be ultra vires. It was done away with. And the Supreme Court said that the older Collegium system, which was decided by us in 1993 and then confirmed by us in 1998, would continue to be the appointment process, and no other change would take place. Okay, so the NJAC was kept aside and we have come back to the same situation now. Okay. Presence of executive contributors. See, it is written here. See the cursor here. It turned into contended that the presence of executive contributors in the NJAC violated the independence of the judiciary. In its judgment, the court held that the government involvement in appointment of judges impinges upon the independence of the judiciary. This violates the principle of separation of powers between the executive and judiciary, which is a fundamental feature of the Constitution. On this context, we take a look at the proposals across the appointment of judges to the higher judiciary. Okay. So collegiums, like it's written here, collegiums inclusive of the leader, Chief Justice of India, and 4 different senior most Supreme Court judges made tips for people to be appointed as Supreme Court and High Court judges to the President. So the older appointment process, the older collegium system, which was decided in 1993 and which was finally composed with exact numbers in 1998 by the Supreme Court, would continue to rule the appointment discourse, and this NJAC is not going to work. Any sort of that conspiracy is not going to work. Okay. Now these are all discussions, like this happened and that happened and this lawyer said this and that lawyer said this. We are not going into the nitties and gritties that what happened in the Supreme Court bar and what were the different opinions of different people from different walks of life in the society. We are just concerned about the objective type things here, and this is the whole story about it. If you have any questions, you are most welcome to ask. No, this is not an amendment PDF. This is a this is a document, PDF document on the issue of appointment of judges. It contains every detail. It contains every detail. I guess questions are not there. I'm waiting. So everything is clear to you. So I am ending the live stream now. Hope to see you next week. Enjoy your weekend and all the very best.